topic is company law. And before starting the company law, we have to know or we have to understand the real face or real meaning of company law. So, company is nothing in the technical sense or in the legal meaning, but it is an incorporation to do some business. And it's an incorporation to do some business means voluntarily someone want to do some business and they do not want to do such with their own names but the name of others. That others create a legal entity. Actually, if we will read the history of company law, we will understand the history of company law, then we can better understand what are the function and meaning of company law. Actually, before 1720, in England, company had to be registered by the Royal Charter or by the Act of Parliament, like East India Company in the India and so many companies. But how the person can get or the peoples can get the recognition from the parliament in each and every case means it was a very difficult process. To ease the process, the peoples of the England made some local organizations, and these local organizations came in existence in the form of partnership firms. So in the form of partnership firms they are doing the business, but we can understood in the form of partnership firms or large partnership firm, government cannot control directly on these partnership firms. And if revenue was generated from the public, how the partnership firm can be controlled by the government and how the government can make the provisions for the social welfare or for the protection of the money invested by the general public. So in 1720, Government of England or Parliament of the England passed a law that was known as the Bubbles Act. In 1720, they passed a law with the name of Bubbles Act. But with this act, the problem was not resolved. So still they was facing the problem. That is why the people was not going to work under the Bubbles Act. That is why in 1844, it was a year of 1844 when the Joint Stock Companies Act 1844 was passed. It was a first major act in this regard. Joint Stock Companies Act 1844. This Joint Stock Companies Act 1844 was passed in England and simultaneously here in India also in 1850. The Joint Stock Companies Act, Indian Joint Stock of Companies Act was also passed. So that a person can do the work with the legal entity with the name of companies. So now after the Joint Stock Act 1844, later on in 1855 they amended it and makes the provisions for the limited liability of the persons. So before 1855 there was no provision for the limited liability of the shareholders, but after 1855 they makes the provisions for the limited liability of the persons. And 1856 the whole laws regarding the company was consolidated. That is why in England the law of companies is known as the Company Law Act 1856. Finally in 1856 they consolidated all the laws in relation to the companies. So in India also, like we said, in 1850 it was passed and now it was known as the Joint Stock Companies Act. After independence we passed the Company Act. It was known as the Companies Law Act 1956. So we can say that the company is nothing but a legal entity. It was formed a legal entity by the persons investing in the joint stock. But how the discrepancies in these matters may be resolved? Because how the government will get the benefits, or what should be the control of government over the companies? We have to read the advantage and disadvantages of the companies and distinction between the partnership firm and the company. Actually, the minor form of the joint stock was the partnership. Right now, on the large estate, the person want to do the functions, then they have to form a company, because partnership firms having some limitations. Like partners may not be more than 20. If the firm is established with the more than 20 persons, then it has to be converted in the companies, or it has to be registered under the Companies Law Act. In case of financial institutions, the partnership cannot be exceed 10 members. If they exceeded 10 members, then they have to form a company. So there is something different between the company and the partnership firm. See, partnership firm is also the association like the company. But in partnership firms, parties are the member as well as the agent of one another. In partnership firms, members are partner as well as the agent of one another. Whatever the benefit they will got, they will obtain, all the benefit must be divided as per the shares in the partnership to the shareholders of the partner. Collectively, the partnership known as the firm. Firm is nothing. Firm is the collective name of the partnership. Whether partners made with some terms and condition to obtain the benefit from the investment by doing the business. So the intention is to do the business in partnership firm. Here in case of companies also, the intention is to do the business. There is also the investors in the partnership firms. Investors are also here in the companies. But partnership firm cannot exceed 20 members. But the company can be from 2 members to unlimited members. There is no limit of the memberships. In case of partnership firm, the collective name is the partnership, collective name is the firm. But in reality, the owner is the partners. But in case of company, this is not the collective name. Company is not the collective name. Company is the separate entity. Company is a separate entity registered under the Company Law Act. So the sole definition or the main definition of the company is whatever the association, whatever the joint stock association, whatever type of association registered under the Companies Law Act is known as the company, nothing else. Because there may be the association for so many purposes under the so many acts, like partnership is also the association, company is association, society is association, clubs are the association. So there may be so many type of association. In all these association, there may be possible that they have to do the business. But why we have to give the name company? Because the company is registered under the Company Law Act. That is why it is known as a company. Otherwise, no. It may be the partnership firms. So partners has to obtain the benefit from the partnership firm directly, whatever the profit or whatever the loss. But in case of the company, loss will be beared by the company and profit will be taken by the company, not by the investors, not by the shareholders. What is the process to form the company? Actually, someone have to make a memorandum that what they want to do. If they will make a memorandum what they want to do, then after that memorandum they will go with that memorandum to the registrar of the companies and they will request to the company, please register it. Who will invest on these companies, because basic requirement of the company are, it must have a memorandum, it must have an article if needed, it must have some accounts, it must have some declarations, it must have some finance, object, purpose, and blah blah. So these persons, whoever want to do the business with a collective firm, or they want to establish a association, they can promote to register it. The parties will promote to register, they will request to the registrar to please register this legal entity. What about before and after the situation of these promoters? Before the registration and after the registration. Actually, before the registration, they are working like as partners. So all the rights are to the partners, all the benefits will be obtained by the partners, all the laws will be beared by the partners. But whenever they will promote to the registrar, please register it as a legal entity, then after obtaining the status of the legal entity, they will it himself known as the partners, the shareholders. Now they will not be more known as partners in the company. They was the promoter only. They promotes the company, please register it. We will do the function through under this company. So now after registration, this company will get a separate legal status, and all the promoters will be known as the shareholders in the company. Means they having the shares, but ownership will belong in the company, because company is a separate legal entity. Means company is the artificial person. In partnership firm, partners are not the partnership firm is not the artificial person, but company is the artificial person. So now the role of the promoters was only to promote the company and to invest on that. On behalf of that investment, they make some contract before registration, and they have to submit all the contracts before the registrar, and registrar had to recognize these contracts. Like you makes an investment, so how the investment will sustain in the company after formation? So your investment will be secured by the contracts made with the name of the company, and you get the recognition from the registrar. So all these things has to be seen by the registrar, that your contracts are valid, invalid, correct, non-correct, whatever, or these will be beneficial for the company, or these contracts will not be beneficial for the companies. So after registration and recognition of contracts made between the promoters, company will come in existence, and they will be known as the contract persons who invested in the company and will acquire the share only. It's mean company is itself a owner. No one is the owner over the company, because it is registered under the Company Law Act, and Company Law Act is saying that the company should be a legal entity, artificial legal entity, not a real legal entity, but the real persons will be known as the promoters only due to the status of promoters. But they should have some extra benefits in the company? No. Because after the existence of the company, when the company come in existence, then the promoters have no role, only they will be known as the shareholders.